welcome along to our first webinar of 2025. I'm Gillian Henderson, Head of Project Management with InnoScot Health. We run these sessions monthly and they cover a variety of topics, all with a focus on innovation and entrepreneurship. Our session today will be recorded and you can find our previous sessions on the InnoScot YouTube channel. Today we're looking at intellectual property. After our brief introduction, I'd like to raise some points on knowledge assets and some important considerations around that. And then we are very fortunate today to be joined by Dr. Julia Darcy of Harrison's IP. Julia is going to take us through some of the basic principles of IP protection and then spend some time on the new Unitary Patent Convention. Julia and the InnoScot team will then be on hand to answer any of your questions at the end. So thanks to those of you who have submitted your questions in advance. Fiona Schaefer, our Innovation Manager, is going to be monitoring the chat. So if you have any questions as we're going through, just pop them in there and we can pick them up at the end. So for background, and for those of you who are perhaps joining us for the first time or aren't familiar with InnoScot, we have been around for 20 years. We were established in 2002 as Scottish Health Innovations, or SHIL, as some of you may remember. And whilst our role has expanded and changed over the years, our core remit has always remained the same, and that is to identify, accelerate and support the commercialisation of innovation from within the NHS in Scotland. We are publicly funded. We receive our funding from the Chief Scientist Office and we are not for profit. So all ideas are assessed before proceeding to our product development process. And the focus for these innovations is always commercial strength, impact and health economic benefit. Post-development phase, we will also manage the relationship with commercial partners, returning royalty and revenue to the boards and innovators. We receive around 100 ideas a year and select about 8 to 10% of them for development. Of those that we don't take forward, we often signpost to other organisations who may be better placed to support or suggest other avenues for that idea. We hold equity in 6 spin-out companies on behalf of the NHS boards with a prospect to return about 15 million back to the NHS and innovators upon exit. We currently manage 30 commercial licences supporting marketing and communications efforts and managing revenue generated and dissemination to the boards, and these are UK and international licences. We also provide commercial advice to the health boards, not only where we take on a project for development and commercialisation, but also for collaborations and wider research. And we also obviously protect the intellectual property on behalf of the boards and innovators, managing that strategy from initial filing through to territorial grant. So this slide is really just to give an indication of the areas of support we can provide. Obviously, our core activity is the identification and protection of novel ideas from NHS Scotland, and the areas of activity in the darker blue represent that. Whilst we do offer that end-to-end product development process, we support health boards and innovators at all points on the innovation pathway. So InnoScot support can be accessed at all points throughout that development process or even before you've firmed up your idea. So if you're at the very start of your journey, we can help support through our education and outreach programmes and entrepreneurship programmes. We hold ISO 13485 accreditation, so we are well placed to advise and support throughout the project on evidence generation, compliance pathway, registration with competent authority or notified body, and legal manufacturer activity. We work closely with industry and academia, so are able to help identify collaborative partners and co-development partners and offer legal support to ensure agreements are in place to protect your interests. So all the ideas that come to InnoScot are assessed, informing our decision on whether or not we can support the development of an idea. We conduct a thorough market analysis and assess the novelty and inventiveness of the idea. The findings of this are shared with the innovators and the Health Board. And for our license support, licensed products and spin-outs, we offer a package of media and comm support and manage revenue return. So whilst Julia is going to focus on intellectual property protection, I did just want to spend a few minutes talking about other knowledge assets and how these too may have value. So knowledge assets, often called intangible assets, can include IP, but more often than not, we use the term to cover other intellectual resources and intellectual capital you may have generated. Now, these assets can include the skills and expertise of staff. They can include processes, R&D findings, data sets and practices and protocols that you may have developed in-house. But very importantly, they do have the potential to have value. So in addition to that, you could develop them for new and innovative purposes, which could lead to the creation of new IP. So I wanted to talk today specifically in the context of collaborating with an external partner and considerations when negotiating any agreements or collaboration agreements. So perhaps you are developing or adopting a new technology. It would be important to clearly define the ownership of any pre-existing knowledge, data, or innovations brought to the collaboration. So whilst the partner will most likely be bringing formal IP to the collaboration, you should also have a strategy for what happens to any IP generated as part of that collaboration, even if it wasn't the intention of the collaboration to generate new IP. And that should include licensing or revenue sharing terms. In terms of confidentiality agreements, before sharing any of your knowledge assets, any research findings or data, it's important to have a non-disclosure agreement in place. In this agreement, you should define what the confidential information is and ensure that you're restricting its use to the collaboration. The duration of this confidentiality agreement should extend beyond the duration of the collaboration. Any collaboration agreement should outline the roles and responsibilities, the relative contributions and deliverables of the project. It should have balanced publication rights so you can retain the right to publish results, but recognise that it may be important to delay publication to allow any IP protection to be secured. There should also be an exit strategy so that if the partnership dissolves, you have a process for how any knowledge, assets or IP will be handled. And finally, financial considerations. There should be fair compensation for sharing your knowledge assets. There should be equitable financial terms for your contribution through fees, royalties, or research funding. And if the partnership leads to commercialisation, you should be able to negotiate for a fair profit share. So with that, I'm going to hand over to today's guest speaker, Dr. Julia Darcy, Chartered and European Patent Attorney for Harrison's IP. Julia specialises in the protection of inventions in the medical, pharmaceutical and chemical sectors. Julia, over to you.
Thank you very much. Thanks for the introduction. So today I thought it would be useful to first go through the various types of IP, intellectual property, and how they work before doing a brief overview of recent developments. So first, I thought it'd be useful to look at why we secure IP rights overall. And really, it's to stop other people taking advantage of your work and your ideas, and to reward the investment that you make in that in terms of time and money. And in a more practical sense, a well thought out IP strategy can make all the difference in attracting in investments and preventing unfair exploitation. So what we try to do is start with the business case. What makes your business and your idea unique? And then once you've identified that, identify IP which can be used to protect that unique aspect. And that leads to an IP strategy which will hopefully protect your invention or your idea as it develops. Your whole team should be made aware of IP and understand the importance and value of their ideas, and that makes it easier to identify and protect your IP. And another aspect I'd say is that you should plan for the long term, and particularly in terms of budget. You don't want any nasty surprises down the line. And IP certainly is a cost, but the flip side of that is that it provides significant value to potential investors. Could I have the next slide? So in terms of intellectual property, there are many different types, and importantly, one idea or product can be protected by many different forms of IP, with each protecting a different aspect of your innovation. And using more than one type of IP helps to strengthen your protection against unfair exploitation of your idea. So we have patents, trademarks, designs which protect appearance, copyright, and as Gillian mentioned, confidential information or know-how, and trade secrets. Many people or businesses underestimate the value of trade secrets. And one thing to ensure, which is slightly outside the scope of this talk, but employees or colleagues that leave your company or working with you should be prevented from sharing proprietary knowledge that isn't necessarily registered. So today we're going to look primarily at patents. Patents are granted for inventions. They protect ideas and concepts. So new ideas that solve problems. And to be patentable, an invention must be novel, inventive, and industrially applicable. Could I have the next slide? There we are. Because they provide very strong protection, they protect against third-party creation, independent creation of your idea. So if a third party comes up with the same idea as you after you filed a patent application, you can potentially prevent that third party from commercializing their idea. They're intended to reward and encourage research and innovation, and they should be viewed as a commercial tool rather than an academic exercise. Because patents provide such strong protection, then there is an involved examination process before you can get a granted patent. So it's not just a case of filing an application, a patent application, and you having granted rights. Often it takes several years to convince an examiner that your invention truly is novel and inventive over everything which has gone before. All amendments must be supported by the application as filed. So your description of your invention must be locked in early. So it's vital to have a clear vision of what sets your product apart from what's gone before. And it's also very important to have a forward-thinking strategy when you file a patent application, to ensure that future technological advances can be protected in as much as that's possible. And one way of trying to to do this is to brainstorm how an invention might change in the future, because you want your patent application, and particularly the claims, to protect against these potential new developments. And by having a forward-thinking strategy, that allows your patent to remain relevant as technology progresses. One thing to be aware about when it comes to, well, most forms of IP actually, but particularly patents, they're territorial. So you need a patent application in each country where you want to seek protection. And if you decide not to proceed with a patent application in a particular territory, third parties are free to use your invention in that territory. So I thought it would be useful to just have a checklist of relevant things to consider when you're looking to protect intellectual property. So first, what is it? What intellectual property should you look at? You should consider different aspects of your idea and different forms of IP which can be used to protect those different aspects. Do you own it? So before you apply, get all the assignment documents in place. Search it. So patent, trademark and design registries are all searchable, and particularly the UK, the European Patent Office and the US Patent Office are easily searchable. And then consider where and when. So when can be difficult because as I talked about, patent applications, the contents of them is locked in early, but any amendment further down the line has to be disclosed in that initial document. So you want to file late enough that you can properly describe your invention, but early enough that someone else hasn't pipped you to the post. And also where, so IP is territorial, so you have to decide where you want to spend your money. Moving on now to recent developments in European patenting. Just considering what the old system was, which still continues in line with the new system as well. So you can file a European patent application. That's a single patent application through the European Patent Convention, which is not an EU body, and many non-EU countries are members of the EPC. So that includes UK as well as Turkey and many others. You prosecute a single European patent application, and at grant, you then need to decide which of the contracting states you want to obtain protection in. It used to be that you prosecuted the single European patent application, and at grant, that matured into a bundle of national patents in the territories where you validated. But the Unitary Patent Convention came into effect in 2023. And using the Unitary Patent Convention, a single request can be made to seek protection in 18 EU states. The UPC is an EU convention, so non-EU states, including the UK, can't join, and many EU countries have also not yet ratified. So, for instance, Spain, Poland, Ireland aren't yet unitary patent countries, and Spain and Poland have said they're not interested, then they're not going to ratify in future either. So as with many new developments, there are new considerations for IP strategy because there are both opportunities and risks. So in effect, the UPC means that you can get protection in 18 EU countries for the normal price of around 4 with a single request. So there are cost advantages if you would normally validate in more than 4 or more countries. So it can be much cheaper and more convenient to enforce. You can enforce across the 18 countries with a single action, and the associated court has the power to grant central injunctions across those 18 countries. So it can make enforcing your patent cheaper than enforcing it in each of the 18 national courts. On the flip side, there are disadvantages as well. The court is fairly new and untested, so there's some uncertainty about how they're going to behave. The main significant disadvantage for me is that the validity of the unitary patent across all 18 states can be challenged throughout its lifetime with a single action. Whereas if you validated in the normal way, the validity could only be challenged across multiple territories with one action using opposition, and that is only available 9 months after grant. The other thing is, the other disadvantages that I've noted here is that you can't drop territories to reduce your renewal costs. So there's a balance really still between early adoption of the UPC, trying to take advantage of the geographical reach while trying to maintain your patent rights. And one way of mitigating risk is to file a divisional application to keep your options open. So moving briefly, just a quick trot through other recent developments. Because patents are territorial, then you generally need to use the local language, and translation can represent a real significant cost. Machine translation can make this a lot cheaper, but of course there are risks associated with machine translation. And normally any mistakes in machine translation would be binding. You'd be stuck with them. And another recent development is, if we could get the next slide. Artificial intelligence. So AI is a hot topic within the patent community. There have been several recent court cases trying to argue that AI should be able to be named as an inventor. So far, the courts have decided against this, and it seems that there's settled case law now that AI can't be named as an inventor. And then there are also the issues of protecting AI inventions. So they're currently protected the same way as other software inventions. So patent protection is available, but they need to be drafted carefully. And legal frameworks are now possibly struggling to keep pace with AI, as has recently been demonstrated with the use of copyrighted works to train ChatGPT and the like. So that's, if anyone has any questions.
Well, thank you so much, Julia. That I feel as though we've probably crammed a lot of information in quite a short space of time there. I'm particularly interested in the UPC, obviously, because it does affect a lot of the InnoScot portfolio, and we do struggle how to make decisions on that. Purely for my own interest, are the renewal costs the same? Are they still billed on a territory by territory basis if you go down the UPC route?
So
Is there any benefit at renewal?
if you go down the UPC route, it's a single renewal for all the UPC territories, and that is equivalent to around the 4 most commonly used territories. So it's cheaper compared to paying renewals separately in each of the 18 states. But if you would only have validated in 3 states, then obviously it's more expensive.
Point. Okay. And if other territories join the UPC, so for example, if Spain changes its mind and does join the convention, does that affect existing applications or grants? No.
So you're stuck with the countries which had ratified at the date when you request your UPC. Okay. So if your application is still pending, then you'd get the benefit of the extra country. But if you'd already filed the request, then you'd be locked out of that extra country.
I've shamelessly hijacked you there. So I'm going to pass over to Fiona now, who has been monitoring the question and answer the question box, and we'll take some questions now.
Yeah, if you've got any questions or queries, do pop them in. That would be great. And one thing that I think you've kind of addressed, but Kate, one question is that, by you filing in the UK for a patent application, how does that fit with the then going on to apply, get cover in other countries? So because a UK patent application only covers the UK, but you need to start somewhere. So could you maybe give a bit of an overview of how you consider when you start? Would you always start in the UK with your first patent application?
Normally, UK-based companies would start with a UK patent application, and then you have 12 months to decide which territories to go into. And within that 12-month period, your invention might develop as well. At the 12-month stage, you file patent applications claiming priority for the UK application in the territories of interest. Or another option is that you could file an international PCT application. And that effectively is a holding process which allows you an additional 18 months to decide which territories to go into. And that is the expensive time when you split your invention into, or you seek protection in multiple territories. So getting that extra 18 months can give you more time to get investment in, which is very useful.
Thank you. I think that sometimes that gets missed with people who file and like for a GP application and then don't really think further along. Well, that actually, as you helpfully mentioned, once it's published, it's also then, if you choose not to protect in a particular territory, then that means that people can still exploit what you've shared in that part of the deal by putting your application in. What would you say are the chief pitfalls when attempting to navigate the whole patenting process, specifically in relation to healthcare innovations? And where would you suggest people go to seek advice?
In terms of pitfalls, it can be difficult to put the money in to develop your invention sufficiently to be able to describe all aspects of it. So if you have a concept which you haven't developed enough to know all the difficulties associated with creating a prototype, then it can be difficult if you file too early and we don't discuss those difficulties, you're restricted by the contents of your application. So that can mean that those difficulties can't be protected. In terms of where you can go, I mean, Scott Health, of course, but also Scottish Enterprise are very useful in providing assistance and advice.
And of course, obviously, your local friendly patent attorney.
Well, of course, yeah.
Sorry. It almost goes without saying. But yes, no, I think there are different resources to sort of support that. And yeah, also speaking to you or to somebody who's knowledgeable about the whole range of different ways that you might protect your intellectual property early allows you to start to think about at what stage in that development, as you were saying, it's quite difficult to balance that. You know, you've got the idea, you want to, sometimes we speak to innovators who really, it's got to be patented, we've got to patent it straight away. And actually, with a bit of development work and design work, actually, you might have a stronger patent or stronger features to actually protect, or particularly stronger inventive step, and may allow you to actually have a better scope and be able to claim something much more specific, but maybe more future-proofed, as you helpfully mentioned earlier. Another question was how do you decide which territories? Because obviously that's the kind of, you've spoken about that, it is a territorial right. But the challenge is then how do you make the decision on that, and what sort of things should people be considering when they're looking to where they might protect their invention?
Well, certainly it will be the biggest markets for your technology that you would want to protect in. The more territories you go into, then the greater the costs. So if you have investment, it would also be that the investors may give you guidance on that. I mean, as a rule of thumb, most people are interested in protecting in Europe and the US, potentially the UK separately to that, because the European patent application does protect in the UK, but in my experience, it's easier to get a granted patent in the UK than before the EPO. Then for medical technology, Australia, India, China can be useful places to protect as well.
And to kind of follow on from that, so if you've mentioned all the markets actually you'd be actually selling into, I remember sort of talking to people early in the past about actually it's sometimes we forget about where we're going to manufacture or make something, which you'd need to have patent protection to stop somebody else making and selling in that country if you haven't got patent protection in that country. Is that?
Yes, absolutely. That's also something that you should consider.
It's maybe still covered by the main countries that that are going to be your market as well. I don't know if anybody's got any more questions. And those are kind of the main things that have come in for us.
Okay.
Well, I think there's.
Oh, do we have more?
Well, it was just one question about in terms of machine learning models and AI, how much detail needs to be disclosed, because that can often be, that maybe comes back to the conversation about trade secrets and balancing on whether you choose to patent or whether you choose to protect by other means. You know, is it that you need to disclose quite a lot of detail? I'm not a software expert, as you can tell with my vague question, but it's that, how do you know, are those requirements changing in the patent environment as well?
Recently, they have been developed in the US to be slightly more restrictive. So in Europe, there's the kind of rule of thumb is that if you have a software invention and it solves a technical problem which falls outside the field of software, then it is likely to be protectable. But if it just relates to software itself, then it can be more difficult to protect. I'm not a software expert either, as you might have noticed from that. But yeah, that's it. The US has recently aligned itself to be more in position with Europe. So it used to be easier to get software patents in the US, and now it's becoming a little bit more difficult.
Oh, that's helpful. Because I think sometimes there's people go, oh, well, I'll just go to the US because that's much more friendly. So like business model patents in the past, and things do evolve though. So take appropriate advice at the right time, I think is still very key in that
and
area.
Things may change again in the US with Elon Musk and the like being so influential. He might be able to bring the US Patent Office into a more software friendly approach.
Well, if there are any other subsequent questions, do feel free to reach out to the team. Equally, if you have an idea that you'd like to discuss, we do have an online submission form, which you can access here by scanning the QR code. To allow us to start that evaluation process, it's useful if you can consider these elements on screen within the context of current clinical practice. Equally, we're happy to have an informal chat if you would like to discuss any of the support areas discussed today. Next month's webinar is focusing on neonatal innovation, and we have a number of near-to-market projects that we're hoping to showcase, just to give some insight into their development pathway. And the sign-up link for that should be available in the next week or so. In May, we are looking at regulatory and compliance, and then we will have a June session before heading into the summer break. We're always open to suggestion on topics, so if you have something that you would like to see covered, do reach out to the team and let us know. If you don't get our newsletter yet, you can scan the QR code to sign up now and keep updated on the next events and innovation news. I'd like to thank Julia for being so generous with her time today, coming along and answering all our questions. And thank you to our attendees too. I hope you found it useful. And as I said, if it prompts any further questions, do feel free to reach out to the team. Thank you very much, everyone.